Lawyers of Reddit, what's your best most badass, I rest my case, moment, story 1 corporate lawyer, so I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating, and I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions I'd worked on across from them. Pretty exciting stuff. He took it in stride and said, jokingly, well, of course it's fine when we ask for it. Story 2 opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, first thing he told me was to tell the truth no matter what. He said the lawyer is never the one who goes to jail, that he isn't going to jail for me, and if I lie, I'm on my own. Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court. I wanted to put my feet up on the table like I was Vincent LaGuardia Gambini, hands behind my head, and say, I'm done with this guy. Story 3 not a case-winning moment, but a motion-winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that Rule A meant they could do X. I tried, multiple times, to point out Rule A literally did not say that. During the hearing, the judge reached behind them, grabbed their Rules of Civil Procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, show me where Rule A says X. Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, Judge, I have nothing to add. It was pretty fun. Story 4 I represented a company that was sued for breach of contract by a former independent contractor. Dude basically alleged that my client wasn't paying him correctly in accordance with the contract. During his deposition, Dude admits that he never reviewed any documents to make sure his allegations were true, never reviewed his complaint before filing it to make sure the allegations in it were true, and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair, even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money. At arbitration, he tries to flip his story and starts giving testimony that is the exact opposite of his DEP, so I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. Story 5 I was on the losing end of this one. I was representing a pro bono defendant who was attempting to regain custody of her children. The family division attorney was laying out his case to the judge for why my client wasn't ready, and his final point was that my client had refused emotional counseling to avoid violent fits of rage that she had inflicted on her children. On cue, my client jumps up screaming, "Fuck you, judge lady. You a stupid cunt. Fuck y'all for taking my fucking kids, you fucking cunts." I just caught the opposing attorney's smirk of satisfaction as I got up to usher my client out of the courtroom. Story 6 when I was in law school, I had to argue a case for an exam. I was the last in my class to go, so there wasn't anyone arguing against me. I opened with a motion to dismiss since opposing had failed to show. The judge grading me chuckled and said, "Touché, counsel." I still had to go forward, but we got off on the right foot and I ended up with an A. Story 7 I was a second-year associate and handling my first trial. I represented the plaintiff. The defendant had an expert witness who had testified previously in about 40 similar cases. This expert came out to my client's property and did a completely bullshit examination of the issue, and his expert report was equally as bullshit. For those of you that don't know, expert testimony needs to meet a certain standard, the Daubert standard, at least in my state, in order to be admissible. This guy basically took some photos and put a ruler on the ground a few times to make his report seem legit. The partners at my firm told me it wasn't worth trying to file a Daubert motion to strike his report/testimony because the case was low value, under $100,000, and those types of motions can be very complex, and didn't want to bill the client for it. I was so angry about this guy being deemed an expert that I came in on a weekend, on my own time, and drafted a 20-page motion to strike his testimony. I didn't bill the client a dime. The defendant didn't file a response to my Daubert motion to strike. Instead, they waited until right before the expert was set to testify. He had been sitting in court racking up fees for 2 full days beforehand. The judge had the jury leave the room, put the expert on the stand, and allowed the defendant to do a direct examination of their expert. The defendant's attorney, not taking my motion seriously, had their inexperienced associate, just like me, do the examination. It was incredibly basic and didn't respond to any of the points in my motion. I was in charge of doing his cross-exam. It was my first cross-exam of a witness, ever. I tore the guy, a seasoned expert witness, apart on the stand. I got his entire testimony and report struck. They also had a second expert witness, who was pretty terrible but not quite as terrible. I also did his cross-exam. Realizing that they were in serious trouble without their primary expert, and their second expert at risk of getting struck, the lead counsel for the defendant, a named partner at a well-known firm, did the direct exam for the second expert. I again did the cross. I got the second expert's testimony struck except for one very, very tiny area. So essentially he was forced to testify with both hands tied behind his back. It was the most gratifying moment of my legal career so far. Story 8. So I call up my client's disgruntled former employee about a contract dispute that he started and that got my client into litigation. After 2 questions, it was obvious he was a lying son of a bitch. I didn't want to call him as a witness. He was prone to act unpredictably. I took down his story as we talked, which was easily proven false by documents and which cast my client in a false and bad light. I did not tell him how I'd caught him in lies. Fast forward one day, I submit a list of known witnesses to opposing counsel, as required by the rules. Witness number 1 was the lying sack of shit. Fast forward to trial, my opposing counsel calls the lying sack of shit as his first witness, and the lying sack of shit acts like a lying sack of shit. He tells the same story on the witness stand that he told me on the phone. I took emails that he wrote and entered them into evidence and proved him a clear liar. My client didn't breach the contract, the party suing did. After the lying sack of shit left the witness stand, I asked the court for a brief recess, granted. I approached opposing counsel. My client was still willing to sign on to the walkaway settlement where no money changes hands and no fault was admitted. We offered the deal 2 months before and it was angrily rejected. Now, suddenly, it was accepted. Story 9. A lawyer friend of mine had written a blog post about a legal subject. Opposing counsel filed a motion. Again, as others pointed out, this is like the small battles which are part of the overall war of the lawsuit, in which they had to cite their reasoning for their arguments. In this particular motion they chose to dig through the website of my friend where they found that blog post which they chose to cite in their own arguments. Basically, they were going for an aha moment. You can't argue against us because you yourself once wrote something which we think agrees with our point of view. Rather than dispute the nitty-gritty details of their argument, my attorney friend simply responded with something along the lines of, "I am honored to be cited as an expert in this area by my esteemed opposing counsel. Now, as their chosen expert, let me tell you what the law means and why they are wrong." It was glorious. They very quickly revised their argument. Story 10. We had a case where opposing counsel was cross-examining our expert witness on hydrology regarding some silt/runoff issues. Mr. Smith, wouldn't you agree that the book I'm holding is highly respected in your field and considered to be the gold standard on the subject? Witness, I am aware that it is highly regarded in my field. Would you be willing to explain, in your own words, what paragraphs 6 to 10 on page 121 is describing? Witness reads the passage word for word. Yes, I can read, but could you put this passage in your own words for the court? Witness, these are my own words. I wrote it, ******. We were the defendants. We were being sued by an HOA over silt in a lake. We were able to prove that we weren't responsible and prevailed. It actually originated from another site and entered the lake, elsewhere. However, that site was owned by a very large corporation, and I don't think the HOA wanted to fight with an entity that could fight forever. Story 11. My sister got T-boned by a car, causing a concussion when I was younger. Long story short, we were in court with the judge, who asked the driver if he had ever sped before. "No, Your Honor, I never speed," was his reply. The judge asked him a couple more times if he was sure, if he never sped. Ever? The driver was adamant that he never sped and never had before. A few minutes later, my sister's lawyer gave the judge some paperwork. She read it, and said to the driver, "It seems that you have some past driving violations. Can you tell me what they are for?" Speeding. The driver had to pay medical bills for my sister. Story 12. I was on the losing end. Represented a guy who had bought a company, and the company failed spectacularly within months due to a number of reasons I could attribute to the seller, and they had clearly lied about the company's finances to induce him to buy. I was suing to rescind the deal, have your shitty company back and give my guy his money back. I laid out my huge case and thought I had it in the bag, and then opposing counsel asked my guy, "Isn't it true that you listed this business for sale a month ago?" "Yes, and you did sell it, correct? You signed a purchase and sale?" "Yes, but he never finished paying me, he has more payments to make." "I'll just give his money back when you guys give me my money back." My idiot client had me suing over a company that he had legally sold. Fucker never told me. Game over on the spot. Story 13. I am relatively junior, so I'm hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial which was to be heard after our motion was argued. That matter was also a professional negligence matter and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove the elements of professional negligence. In fact, he said, "I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence." Our matter was then called and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Story 14. I had a trial against a guy who was self-representing and he was constantly asking my client about conversations she had with me. First of all, no, I'm not coaching her to lie, and second of all, there's a thing called privilege, which means the things we discuss are not compellable. It was an exhausting trial. Needless to say, he was ordered to pay about $1 million more than he actually owed. Story 15. As a young attorney, I had stated a claim that an insurance company was dragging out a case in bad faith, in hopes that my elderly client would die before they had to pay him. I was requesting that the trial date be given priority due to my client's advanced age. The judge was no spring chicken himself, and seemed skeptical when he asked exactly how old my client was, maybe thinking that he was in his 70s and must merely seem ancient to a baby lawyer like me. When I responded that my client was 92, and the case has already gone on for 5 years, the judge was visibly shocked, and immediately granted my motion for priority, shutting down the insurance company's attorney's attempt to respond. They wrote us a check for $1 million the next week. To be fair, the check would have been a lot smaller if they hadn't tried to wait him out. His actual damages were only a few $100,000 max, but the bad faith insurance claim opened the door for a much higher recovery, in excess of the policy limit. So when they saw we had a fighting chance at getting that, they just gave us the entire policy limit to settle. Story 16. I represented a man in a slip and fall case in a national chain that grills chicken. The restaurant is not supposed to clean the grills until after they close because it is a huge sloppy mess that involves using a garden hose after applying chemicals to remove all of the grease. The close-down process can take up to 2 to 3 hours that involve packing up the food for the next day, scrubbing the grills, mopping, etc. Even though the corporation knew this, they refused to pay more than 1 hour worth of wages after closing time. Thus, the shift managers and cooks decided that they would start the closing process 2 hours before closing while there were still customers in the restaurant. This is really dangerous as employees delivering food can track the greasy water into the lobby where the customers were. On one fateful day, 2 hours before closing, one of the cooks was cleaning the grills and using the hose to wash them down. This slurry is so slick that the cook has to wear a plastic smock and slip-resistant shoes for the process. While he was waiting for the chemicals to remove the grease, which takes about 15 minutes, the cook goes into the lobby tracking this stuff into a hallway to wipe down some tables. My client walks out of the restroom and slips in the greasy water. He hits his head so hard that it causes a subdural hematoma, which requires surgery to relieve the swelling and blood from the brain. Go figure, the video system wasn't working that day. In any case, right after that the cook was fired and the corporation claimed that they could not locate him during litigation. I did some research and found a relative of the cook, which eventually led to me finding him. He admitted that he was cleaning the grill, but denied that he was the one that tracked the greasy water into the lobby, as did all of the other employees. The corporation during the entire 3-week trial testified that cleaning before closing was against their policy and it never happens. Thus, it had to be anything else that caused my client to fall. I was talking to the cook before trial because we were going to call him as a witness. He was pissed that they fired him. I asked, "Do you think they are still cleaning before closing because they are denying that they do?" He told me, "Absolutely." On the first day of trial, I sent my investigator to the restaurant at the time my client was injured, which was 2 hours before closing, to record video on his cell phone whether they were cleaning or not. Guess what? They had the hose out and everything. I couldn't believe that they would continue to do this at the restaurant at issue in the case. I told my investigator to go back up there when there is a different shift manager and cook to see if they are doing the same thing. They were. At the end of the trial, the defense put on their general manager for the region. He swore up and down that this never happens. He was their last witness. We get up and say, "Judge, we need a sidebar." In the judge's chambers we revealed the videos to the other side. The attorney for the corporation was freaking out. The judge let it in for rebuttal. The last thing the jury saw before going into deliberations was 5 minutes of video with audio of the hose as they were cleaning the grills 2 hours before closing. We completely wiped out their entire defense in a 3-week trial with that video. Needless to say, we prevailed. I should add, using sub rosa video against a defendant like this is very rare. They usually stop doing what they are not supposed to be doing during the trial. I guess the restaurant didn't get the memo. Story 17. I do mostly solicitor work, so if I'm doing my job right, I don't get a whole lot of these type of moments. That being said, I had a long-time client who was being sued and I got to shut down the guy suing him in a very satisfying way. So my client had hired a guy, we will call Kevin, as basically a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed-upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds that the small changes involve removing the duties and responsibilities section, basically the job description, and the non-compete/confidentiality clause. Not only that, but he has written in a higher salary than agreed and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out or he can find himself another job. He takes the latter option. But he starts a lawsuit against the owner wanting to be paid for the 6 weeks he was supposed to work, which had already been paid, 2 weeks in lieu of notice and 5 weeks vacation pay. I got the enjoyable job of telling Kevin, in front of a judge that he was not entitled to anything under the employment legislation and the only way he could get any of that would be if he had signed the contract. Judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. Story 18. I am not an attorney, and it wasn't in front of a judge, but I got into a dispute with a contractor who fucked up royally when installing a new heating system, resulting in an asbestos contamination of my house. Their insurance argued the contractor couldn't have caused the contamination, because the contamination was way worse than could have been possible from what the contractor did, which is bullshit. They argued the contamination must have been caused by the contractor that installed the previous heating system. It was super satisfying to write our response. The previous heating system was placed 12 years earlier. The asbestos dust was visibly lying everywhere. Arguing we didn't vacuum for 12 years was beyond ridiculous. The asbestos dust was on a floor we installed 6 months earlier, included the receipt for the floor, and then the third point was the most fun to write. 3. I said they were welcome to believe the contamination was caused by the contractor who installed the previous system 12 years ago. I included the receipt of that installation. It was done by the same contractor. The next letter was very brief, stating they would pay us for all damages we were claiming. Story 19. Not a lawyer, but during a particularly nasty employment mediation hearing, I got to ask my former employer a question about payments per employment law. Me. Did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence. Mediator. Sir, answer the question. Silence. Mediator. Well, let me ask it. Did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence. Mediator. I'll take that as a no. Story 20. I was representing a woman with a severe neck injury. Opposing counsel presented a test result that showed her cervical exam was normal. I felt almost bad when I pointed out he had the wrong cervical area in mind. Story 21. Complaining witness accused my client of harassment/stalking. Said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. Girl had dozens of photos of the guy, who was clearly her boyfriend. I showed her one such picture. This is Mr. So-and-so, right? Yes, in this photo, he's on a bed. Yes, the bed is yours. Yes, the bed is in your bedroom. Yes, you took this photo of him. Yes, he's smiling in the photo. Yes, and in this photo, he's wearing your brassiere. Yes, no further questions, Your Honor. Story 22. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you?" He said, "Yes." In England, we don't say, "I rest my case." Instead, I looked up at the bench, said, "No further questions," and sat down. It might not seem badass, but I got the defendant to admit the offense with one question. That never happens. Story 23. Usually because going there is likely to cause some sort of issue with antisocial behavior. Maybe he was intimidating someone on that street, or was in a gang with someone who lived there, or something. An antisocial behavior order, ASBO, in the UK is a way of making, basically, not a lawyer, a law specific to one person. E.g., it's, effectively, illegal for you to be out of your house after 10 p.m., or to associate with certain people, or go to certain places. I'm not entirely comfortable with the idea as I feel it is open to misuse, but I can see that if applied fairly and sensibly it's a useful tool. Story 24. Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed his vehicle could only get to 55 miles per hour and not the 67 miles per hour he was clocked at. The ADA then moved to have another speeding ticket issued because the actual posted speed limit was 50 mph. Story 25 IP lawyer, deep in a set of terms and conditions on a website, our client's details, name and contact details, were listed. So it is very evident that they just copy-pasted our client's legal terms and conditions and missed a couple of details they needed to change. I was handed the matter, did a quick Ctrl+F for client details, and it was an open and shut case, not really that impressive, but saved me hours of time going through each term one after the other, noting exact similarities for a letter of demand. Story 26 I was helping a client gain custody of his infant daughter. He insisted that baby mama was on drugs and his first attorney tried in vain to get him to understand just how favorable our state is to 50-50 time unless he can prove by a pretty high standard that she was on drugs. The problem is that he kicked her out because he had suspicions, but then one day found needles and a substance in the other baby daddy's, bedroom. This was all wrapped up in an old dish towel with a band, the type you put around your arm for shooting up, name, and a spoon. She tells him every fucking lie, don't know, not mine, only tried once, etc., but he refuses to believe her and kicks her to the curb. So he fires first attorney and hires me and I go straight into client control mode, heavily managing expectations, while doing everything I can to put requirements in place to catch this drug use, and we're getting nowhere. The trial problem we have is it's a one-time thing, she's a good liar, even by legal standards, and we have nothing current to show a pattern, but he insists, so I file to restrict her time and we go to court. She's such a good witness and the judge buys every bit of it. On cross she testifies that she only ever shot up the one time ever and that's the only time she ever used anything illegal and she just knew how to shoot up because she didn't know. I thought I had a pretty good cross, it took some time, but I felt like we got what we needed. But we lost, and the judge gave her essentially 50-50 time, ordered us to mediation, and set up some regular drug screens. We go to mediation and put in place a parenting plan that sets up a little more detailed 50-50 custody schedule, but also requires regular urine drug screens and some more detail about those screens so we can be sure she isn't constantly trying to beat the tests. Best I can do with the facts. I caution him that all we can do is pay attention to the screens, stay on top of it, and take her into court under an emergency motion at the first slip-up, but she is so good. She's supposed to take the screens within 24 hours of a request, but always has an excuse and is just a couple days or so late. Also somehow almost all of her screens are on Wednesdays, later find out a friend works those days. Also, mysteriously, she refuses to give me direct access to the screens, but provides them to her lawyer who faxes them to me. I immediately start sending faxes, he was old school, no emails, and an asshole, so no phone calls, and telling him I consider this contempt and he better cure it or I will file. My client is furious at each contempt, but the standard for this is so high and we've already been in court once and didn't do well, so I really needed to build a case. So finally we get quite a few weeks of ridiculous behavior. And my more than reasonable attempts to address it with her attorney. I file for civil and criminal contempt and we go to court. An important detail is that she has another baby daddy who was fighting custody at the same time for the same reasons and has required drug screens. I'd been in contact with his attorney and we were sharing information. I find out that the night before our hearing she had completed a urine drug screen and passed it. So when we get there I caution my client about getting his hopes up. Remind him this is a long game. She's late and judge starts without her, no fucks given. Her attorney surprise withdraws. He says it's because of lack of communication. She finally shows up as I'm giving the rundown of my motions. I run through the timeline of missed screens, delayed screens, a screen that failed because her sample was too diluted, etc. And the judge looks at her and she gives all the excuses in her very sweet and innocent way. The judge listens, then asks how she would test that day. She says she will be clean. So they screen her, and she fails for exactly what we expected. The judge asks why, and she tries what are clearly excuses this time. Changes her story to fit the facts, and he cuts her off and tells her he doesn't believe her. He orders her to 4 hours a week supervised visitation, and she has to pay dad support until she completes an intensive outpatient drug treatment program, at which time she can regain some of her custody. That little girl just turned 5 and mom has never visited, and to my knowledge has never completed any treatment. She also hasn't paid a dime, which my client doesn't care about and doesn't care to pursue. It's a small town. He said he saw her in a restaurant once and she walked right by her daughter and didn't acknowledge her. I've seen her out once with friends partying without a care in the world, it seemed. Sorry for typos and if garbled. Had to get in before my plane takes off. Story 27. It wasn't at trial, though we had one of those and I won it easily. Just always stuck with me because of how clearly the law supported my position to the point that it was inarguable otherwise, and also because of how ridiculous the claim of monetary damages was. Guy moved out of his apartment, turned in his keys, then came back 15 days later demanding access so that he could retrieve belongings that he had left behind, which at that point had been trashed. It was just some minor furniture type items. Lampshade is the only thing I clearly remember, and a box of his college notebooks, i.e. notes he took during class. He is furious and sues the landlord in small claims for $5,000, state maximum, because his notebooks have such huge value. Apparently, they hire me and I respond, which moves the case out of small claims. It's just the way it works here. After time in our /legal advice, I know this is not the case for every state, but our rule is better than yours. But enough aside. This puts him at a huge disadvantage because now he can't rely on the lax rules of small claims, so he goes out and hires a lawyer. The lawyer calls me to try to talk settlement. I know her pretty well, so I wasn't rude or anything, but I kind of scoffed and was like, no, that won't be happening, and direct her attention to a particular state statute, then read it out loud to her. This statute, unlike everything else in the law, isn't overly long or wordy or hard to follow. It just says bluntly that when someone actually moves out and gives notice of this, items left after 10 days are abandoned, period, end of story. I could feel her deflate on the phone and encouraged her to dismiss the suit. She did not. We proceeded to a short bench trial in district court that we won.it would be her client's decision to drop, and I assume that's why she went forward to the hearing. But yes, she also had the option of dropping the client. That being said, I do think it was easier for her to have the judge tell her client no than it was for her to do so, and that affected the decision for her to proceed as counsel. It's an interesting situation, to me at least, because she didn't file the suit originally, or an amended complaint, but had she, I would have probably asked for Rule 11 sanctions to be entered because it was a lawsuit that was wholly without merit. In that case, there are only 2 reasons for it being filed, and I think sanctions are appropriate in either case. The controlling law on the issue was not reviewed prior to filing, which is a basic ethical duty and something you are explicitly agreeing you have done when signing your name to a pleading. The law was reviewed and the suit was filed regardless, and you also explicitly agree that the suit has merit by signing your name to a pleading. Story 28. I represented a poor woman whose husband left her and their child behind. He was, of course, unemployed. He did not want to pay and started his plea with how much he loved his child but couldn't afford anything. I started to laugh, which was of course a bad move of me, the guy, his lawyer, and the judge stated that it was unprofessional for me to laugh. I luckily came back, presented his rental bill, petrol bill, and phone bill, together forming 2 times his welfare check without his daily bar tab, so we can only conclude he has a job in black, and that he chooses not to pay for his beloved child. The judge looked at him, he couldn't reply, and we finally won with him needing to pay 1.5 times his welfare check to his ex-wife. Sadly, he fled to North Africa to escape the sentencing. Story 29. Obligatory. Not a lawyer, but I was defending myself against a debt collector for a debt so old I could not even remember for sure that it was mine. Me to the debt collector: can you provide the actual contract bearing my signature along with a chain of title to the debt? Debt collector's lawyer: crickets. I look at the judge to lawyer: well, can you? Debt collector's lawyer while looking through paperwork: well. No, not at this time, Your Honor. Judge, case dismissed. Note, to prove that a debt collector owns your debt, they must prove how it came to own it. Often, old debts are sold and resold over and over again to a number of subsequent debt buyers. When this happens, the debt collector must prove each and every assignment by showing a chain of title reaching all the way back in history to the original creditor. More often than not, for old debts, it is impossible for the collector to show this. Story 30. I once had an appeal where the precedent, all from other circuit courts, was very bad for me. The circuit court I was arguing in front of had a decision that was very good for me, but it was unpublished, meaning that it was not precedential. My goal was to convince the court to follow its unpublished decision, not the decisions of the other circuits. During my argument, I cited the unpublished decision. One of the judges interrupts me and asks, "But wasn't that decision unpublished?" I answered, "Yes, but it was well reasoned." He replied with a self-effacing quip, "I was on the panel for that decision, so it couldn't have been that well reasoned." The audience laughed a bit. I answered quickly, "In that case, Your Honor, it was at least well written." The audience, and all the judges, burst into laughter. I ended up winning in a published decision, which turned the old unpublished decision into binding precedent. A bit of humor can go a long way in the courtroom, especially when you're flattering the judges. Story 31. Once had fairly standard RTC case. My client going round a roundabout in a small car got sideswiped by a lorry driver. Claim for damages, loss of earnings and the rest. Other side's entire case rested on whether the lorry driver saw my client or not, as we could prove from CCTV that my client was well within her lane, within speed limits and generally on solid ground. Legally speaking, their client gets into the witness box and is asked if he saw my client. Well, you can't ask leading questions to your own client. A napkin could tell he was being prodded towards saying no. The man promptly responds, I did. But the bitch shouldn't have been where she was. My cross-examination consisted of getting him to repeat that answer and then sitting down. To date, the easiest day in court I ever had. Story 32. I've had a couple such enjoyable moments, though they have all been, no further questions, moments, as, I rest my case, is not something I get to say in family court. I apologize in advance for what is likely to be a pretty lengthy post. In the first ever domestic violence restraining order, DVRO, case I had as a new attorney, I represented a woman who has broken up with her ex-boyfriend after he has shoved/hit her. She filed for a DVRO when he continued to harass her and show up uninvited to her place. The process for getting a DVRO, at least in my state, is the victim files documents describing the alleged abuse, and a judge decides to grant a temporary restraining order, with a hearing scheduled within a couple weeks, where each side can present their case. Even after my client got the temporary restraining order, her ex continued to try to contact her, including randomly showing up where always she took her dog for a walk at 5 a.m. the morning of the hearing, even though this was 25 miles away from where he lived. At the hearing, even before either party got to testify, the judge reiterated that any violation of the temporary restraining order, including attempted contact with the victim, was grounds for a permanent DVRO being issued. The judge ended up ordering a brief recess before we were to introduce evidence/testimony. During the recess, my client went to the bathroom, and the ex decided it would be a good idea to follow her into the bathroom to talk her out of pursuing the DVRO. He had not noticed that the bailiff was also using said bathroom, and the bailiff immediately ordered him out of the women's bathroom and threatened to arrest him. When we got back into the courtroom, X took the witness stand to testify. I asked him if he had just attempted to enter the women's restroom to make contact with my client. When he answered affirmatively, I smugly stated that I had no further questions. The judge tore him a new one, and the DVRO was immediately ordered. On one other DVRO case I handled, I was defending a husband who was accused of completely unsubstantiated, and clearly fabricated, abuse by his train wreck of a wife. My first question for the wife when she took the witness stand was, "Isn't it true you made these allegations and are requesting this DVRO solely for purposes of gaining an advantage in custody and support proceeding?" I obviously assumed she was going to deny it, and was really just planning to try to get her angry on the stand so she'd slip up and give inconsistent or conflicting testimony. When she answered yes, the judge looked as surprised as I was. I immediately stated that I had no further questions, despite the fact that I had prepared at least 40 to 50 questions for her, and sat down. The judge tossed the case moments later. Story 33. I helped the prosecution rest his case. Loli got jammed up during spring break doing dumb spring break shit. So there I was in court to face the music, misdemeanors. As I sat there waiting for my turn, I watched person after person go before the judge. The prosecutor read their charges and some information from the police report, stating what the potential max sentence was for each/all, I don't remember exactly. Then the judge asked what plea they wanted to enter. Almost everyone said, not guilty, and I could see that both the judge and prosecutor were getting tired of their bullshit. Finally, my turn came. I was probably second to last after what seemed like hours, but may not have been. The prosecutor read off my charges and cited the police report. The judge looked at me with this "let's just get it out of the way. Tell us you're not guilty" look and asked how I pled. Guilty, Your Honor. The judge and the prosecutor both looked at each other and the judge said, "Kid you not, say again, or beg your pardon." Guilty, Your Honor. I did it. Just the way Officer So-and-so's report reads. They exchanged looks again and the prosecutor held his papers at arm's length as if to get a better look at them and did the unthinkable. Your Honor, this all reads to me like a case of college prank gone bad. The county moves to reduce charges to XYZ. I walked in there expecting some jail time and walked out paying like $110 plus costs. I didn't really know how to feel about the scariest day of my life turning into one of the happiest ones.